Be ready. Start. The decree should be framed by the judge with the most careful attention. It must agree with the judgment and be not only complete in itself but also precise and definite in its terms. It should specify clearly and distinctly the nature and extent of the relief granted and what each party affected by it is ordered to do or forbear from doing. Every declaration of right made by it must be concise yet accurate. Every injunction simple and plain. In decrees for possession of agricultural land, it should be stated whether possession is to be given at once or after the removal of any crop that may be standing on the land at the time when the decree is executed or on or after any specified date. In appellate courts, the language used in filling in the decretal order shall conform to the action recognized by the law and shall direct that the decree of the lower courts be either affirmed, varied, set aside, or reversed. In each case in which a decree is affirmed, the terms thereof shall be recited so as to make the appellate decretal order complete in itself. In varying a decree, the relief granted in lieu of that originally granted shall be fully and accurately set out. Where a decree is reversed on appeal, the consequential relief granted to the successful party shall similarly be stated. Every decretal order shall be so worded as to be capable of execution without reference to any other document and so as to create no difficulty of interpretation. Under Section 2 of the Code of Civil Procedure, a decree may be either preliminary or final. A preliminary decree should be based on a preliminary judgment. In cases where mean profits are asked for in the plaint, the question as to the amount thereof, if any, which should be paid to the plaintiff in respect to the period of dispossession before and up to the date of filing the plaint must be determined at the hearing of the suit and decree must specify clearly the portion of this amount which each defendant is to pay either severally or jointly with others to the plaintiff. When a decree is to be passed on the basis of a compromise, the court should order the terms of the compromise to be recorded in accordance with the provision of Order 23, Rule 3, Civil Procedure Code, and then pass a decree in accordance with the terms. When, however, the compromise goes beyond the subject matter of the suit, a decree can be passed only in so far as it relates to the suit. Thank you.